Assalamu alaikum, and welcome back once again to Today in African History with Baba Shaka. I'm Baba Shaka, and today is May 18, 2021. And it was on this date, May 18, 1896, that the highest court in these here yet to be United States ruled that the doctrine of separate but equal was indeed constitutional. Now, those of you who have been regular viewers of this channel will undoubtedly notice that we're trying something new. Yes, we are recording in the great outdoors, or rather, in the front yard. It's a beautiful day, so we decided to come out and mingle with the birds and the bees. Welcome to spring. Now, I've often heard people argue about what the U.S. Constitution means, academics and non-academics. Now, most of us, I'm sure, have heard various talking heads on the idiot box that we call television argue that the Constitution means this or the Constitution means that. All that is hot air. Now, when I was a student at Lincoln University in Pennsylvania, I distinctly remember my constitutional law professor, Dr. Richard Winchester, explaining that the Constitution means just what the Supreme Court says it means. Now, what that means is that the Constitution means whatever the sitting justices tell us what it means. It's a lot of means, right? You don't believe me? Okay. Let's take a look at the doctrine of separate but equal. Plessy versus Ferguson was a landmark 1896 U.S. Supreme Court decision that upheld the constitutionality of racial segregation under the quote-unquote separate but equal doctrine. The case stemmed from an 1892 incident in which African-American train passenger Homer Plessy refused to sit in the car for black people. Rejecting Plessy's argument that his constitutional rights were violated, the Supreme Court ruled that a law that, quote, implies merely a legal distinction, unquote, between white people and black people was not unconstitutional. As a result, unrestricted Jim Crow legislation and separate public accommodations based on race became commonplace. Now, after the Compromise of 1877 led to the withdrawal of federal troops from the South, Democrats consolidated control of state legislatures throughout the regions, effectively marking the end of Reconstruction. African people in the South saw the promise of equality under the law embodied by the 13th, 14th, and 15th Amendments to the Constitutions receding quickly, and a return to disenfranchisement and other disadvantages as white supremacy reasserted itself across the South. As historian C. Van Woodward pointed out in a 1964 article about Plessy versus Ferguson, white and black Southerners mixed relatively freely until the 1880s, when state legislators passed the first laws requiring railroads to provide separate cars for, quote, Negro or colored passengers. Right? Florida became, no doubt, right? Florida became the first state to mandate segregated railroad cars in 1887, followed in quick succession by Mississippi, Texas, Louisiana, and other states by the end of the century. As African people in the South witnessed with horror the dawn of the Jim Crow era, members of the black community in New Orleans decided to mount a resistance. At the heart of the case that became Plessy versus Ferguson was a law passed in Louisiana in 1890, quote, providing for separate railway carriages for the white and colored races, unquote. It stipulated that all passenger railways had to provide these separate cars, which should be equal in facilities, and I emphasize the word should. Now, Homer Adolph Plessy, who agreed to be the plaintiff in this case aimed at testing the law's constitutionality, was of mixed race. He described himself as 7/8 Caucasian and 1/8 African blood. Now, on June 7, 1892, Plessy bought a ticket on a train from New Orleans bound for Covington, Louisiana, and took a vacant seat in the whites-only car. Now, after refusing to leave the car at the conductor's insistence, he was arrested and jailed. That's when he found out that 7/8 Caucasian blood meant nothing, sort of like Tiger Woods. All right. Convicted by a New Orleans court of violating the 1890 law, Plessy filed a petition against the presiding judge, Honorable, or some people would say dishonorable, John H. Ferguson, claiming that the law violated the Equal Protection Clause of the 14th Amendment. Now, over the next few years, segregation and black disenfranchisement picked up pace in the South and was more than tolerated in the North. So don't think the North was innocent in all this. Right? They might have been a little soft about it, but yeah, the North is tolerating the North. Congress defeated a bill that would have given federal protection to elections in 1892 and nullified a number of Reconstruction laws on the books, sort of like what's happening today in Georgia and Texas and a couple other states down low, right? Then on May 18, this date, on May 18, but in 1896, the Supreme Court delivered its verdict in Plessy versus Ferguson. In declaring separate but equal facilities constitutional on interstate railroads, the court ruled that the protections of the 14th Amendment applied only to political and civil rights, like voting or jury service, but not to social rights, like sitting on the railroad car of your choice. In its ruling, the court denied that segregated railroad cars for African people were necessarily inferior. Quote, "We consider the underlying fallacy of Plessy's argument," Justice John Henry wrote, "to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it," unquote. So we get treated equal because we choose to put that construction on it. See what I'm saying? Yeah. Crazy thinking. Now, alone in the minority was Justice John Marshall Harlan, a former slave owner from Kentucky. See, Harlan had opposed emancipation and civil rights for free slaves during the Reconstruction era, but changed his position due to his outrage over the actions of white supremacist groups like the Ku Klux Klan. He was like, hey, I don't like black people, but damn it, man, you just can't go around stringing them up, right? Harlan argued in his dissent that segregation ran counter to the constitutional principle of equality under the law. Quote, "The arbitrary separation of citizens on the basis of race while they are on a public highway is a badge of servitude wholly inconsistent with the civil freedom and equality before the law established by the Constitution. This cannot be justified upon any legal grounds," unquote. That's what he wrote, okay? Unquote. Okay? Now, the Plessy versus Ferguson verdict enshrined the doctrine of separate but equal as a constitutional justification for segregation, ensuring the survival of the Jim Crow South for the next half century. Interstate railroads were among many segregated public facilities the verdict sanctioned. Others included buses, hotels, theaters, swimming pools, and schools. Now, by the time of the 1899 case, Cummings versus the Board of Education, even Harlan appeared to agree that segregated public schools did not violate the Constitution. Hey, I don't mind you black people sitting next to me on the bus or the train, but I don't want your kids going to school with my kids, right? Now, it would not be until the landmark case, Brown versus the Board of Education in 1954, at the dawn of the Civil Rights Movement, that the majority of the Supreme Court would essentially concur with Harlan's opinion in Plessy versus Ferguson. The court now consisted of a different set of justices, right? Now, writing the majority opinion in that 1954 case, Chief Justice Earl Warren wrote that, quote, "The doctrine of separate but equal has no place in public education and calling segregated schools inherently unequal, and declaring that the plaintiffs in the Brown case were being, quote, deprived of the equal protections of the laws guaranteed by the 14th Amendment," unquote. So, as you can well see, the Constitution, the Constitution changes meaning depending on who is currently sitting on the bench. Different justices, different court, different meaning to the Constitution. So while we're arguing about what this means and what the Constitution doesn't mean and so on, no, all of us are wrong because we have to wait until the Supreme Court tells us what it means. And the meaning will be determined based on who is sitting in the Supreme Court. So thank you, and thank you again to all of our subscribers. Your continued support is what keeps us going. Now, to those of you who have not yet subscribed, this is a good time to hit that subscribe button just below the screen and join us on this journey of producing these daily lessons. Please like and leave a comment down in the comment section below. But most importantly, please share, especially with the young amongst us. So, until tomorrow, inshallah, this is Baba Shaka with Today in African History. Masalam.